Okay, thanks very much. Hi, this is Gary Kibel, and as Christina mentioned, I'm a partner at Davis Gilbert, a law firm in New York, and I practice mostly in the areas of digital media and privacy. So today we're going to talk about the California Consumer Privacy Act, the CCPA, and I'm happy to take your questions at the end. I probably have many more slides than we have time to go through, so I may skip through a few here and there. But I'm certainly happy to share some information with people afterwards if we skip over something you're interested in discussing. All right, so to get started, in the United States, as we sit here today on November 26th, before CCPA is enacted, is effective on January 1st, on the federal level, when it comes to privacy law, privacy is really regulated by one sentence under the FTC Act. Now, there are sectoral laws that apply to financial data, healthcare data. You probably all know about HIPAA from going to your doctor's offices, and children's data, but there's no comprehensive law on the federal level in the United States that addresses privacy for every industry. They rely upon this one sentence from the Federal Trade Commission Act. It says unfair methods of competition in or affecting commerce and unfair deceptive acts or practices in or affecting commerce are hereby declared unlawful. That's it. That has been to date what regulates privacy in the United States. This is the same sentence that's used for advertising. So if you have a car commercial that says the car goes 0 to 60 in 5 seconds, but that's not true, that's deceptive. But this one sentence has been applied to privacy as well. So if you have a privacy policy and you disclose how you process information and that's wrong, that could be deceptive. If you collect personal information from someone and you have a security incident, a breach, that can be viewed as unfair. And that is how the federal government enforces privacy. Well, then along came California and introduced what is truly the nation's first comprehensive privacy law. Now, you're going to hear the word consumer quite often, but you need to keep in mind that consumer is an individual. It's not necessarily someone purely in the B2C context. So who does CCPA cover? Because you may say to yourself, my company doesn't have an office in California. I don't think I'm covered by this law. Well, the law, like many privacy laws, is focused on the data and the individual, not where the business is located. So it applies to businesses that do business in the state of California that collect personal information, determine how it's going to be used, and meet one of the following 3 thresholds. Either 25 million in annual gross revenue, processing more than 50,000 records a year, or deriving 50% or more of your annual revenue from selling personal information. So if you're a SaaS company in New York or Texas or Florida, but you process more than 50,000 records of people located in California, CCPA is going to apply to you. And if you are providing services to a company who is otherwise covered by CCPA, then you may have obligations there as well. So at a very high level, what does CCPA require? I put it sort of into 3 major buckets. It requires heightened transparency, new access rights for individuals, and this opt-out of the sale of personal information. Transparency, what that means is we all have privacy policies out there on our websites and on our online services. Under CCPA, there are specific new requirements that must be in a privacy policy. You have to disclose things that you may not have disclosed previously, such as the categories of sources from which you collect information, the categories of third parties with whom you share the information, more detail about the type of information. And then you need to disclose these new access rights that individuals will have. Individuals now have a right to know, a right to delete, and a right to opt out. What are these? A right to know. An individual can contact you and say, I want to know what personal information you have about me. As we sit here today at the end of November, if somebody reached out to you right now and asked that question, Unless you had made a commitment otherwise to honor that request, you wouldn't have to. You could politely say, thanks, but I'm not giving that information out. After January 1st, when this law becomes effective, you will need to comply with those rights, right to know. In addition, the individual can have a right to delete. They can say, I want you to delete this information you have about me. Now, as any law is very complex, there are actually 9 exceptions to that right to delete to allow you to keep information if it's necessary for fraud prevention, auditing, fulfillment, warranty, financial reporting. There's a number of reasons why you can keep it. But in general, the individual has a right to delete. And then there's a right to opt out. The individual has a right to tell you to not sell their personal information. Now, you may say to yourself, that's not my business. I don't sell personal information. But you need to understand that these terms are incredibly broad. The term personal information covers much, much more than just a name, email address, and phone number. It covers any online identifier, an IP address. It even covers browsing history, geolocation data, and a catch-all, inferences drawn from any of the information. So it is incredibly broad. So if you have a website and it drops a persistent identifier, such as a tracking cookie, you are now collecting personal information. So going back to our threshold test, if 50,000 people in California visit your website, or let's say 10,000 people in California visit your website, but they also access you on a mobile device and on their laptop and through other devices, you can easily get to 50,000 records in a heartbeat. So what is sale? You may say to yourself, we don't have a business where we take money for selling information. Well, the way they define sale is it's not just selling information for monetary consideration. It's transferring it or making it available to anyone else for monetary or other valuable consideration. So if you work with a company that puts a tracking pixel on your site and drops a persistent identifier from your site, and in exchange, you're getting some analytics, you're getting some other value, that is actually the sale of personal information. If you are selling personal information, CCPA requires that you put a standalone new link on your website with the very scary words, do not sell my personal information. Now you can imagine most businesses do not want to put a link like that on their website. So many clients that I'm working with right now are painfully going through an analysis of everything that happens on their service to try and avoid falling into the sale category where they have to put this link on their website. So there are 3 types of entities under CCPA, and you need to understand where you fall because you have different obligations based on each designation. Firstly, there's a business. Think of the business as the party who's really in control of the data, the one who's determining what's collected and how it's going to be used. They are obviously covered by the law. I'll skip to the third one, a service provider. What is a service provider? That might be a hosting company, email service provider, SaaS platform, some other type of entity who specifically is only using the personal information for the benefit of that one business in the context of their contractual relationship. So if you are a company and you receive data through your SaaS platform from your customer and you only use the data for the benefit of that customer, you are a service provider. But what if you get the information from a business and you use it for other purposes? Then you're what's called a third party. And when a business makes available personal information to a third party, that is deemed to be a sale. So if one of your business customers uploaded personal information to your platform, but you're allowed to use it not just for them, but for your own benefits, you would not be a service provider, you would be a third party. That would be a sale of personal information, and the business would have the obligation to give consumers the right to opt out of that sale. And that's what makes this somewhat challenging. I talked a little bit earlier about the access rights. So consumers, and again, that's any individual, can contact you and ask for the categories of data that you have about them, the sources of data, the business purpose, the categories of third parties, and the actual specific pieces of data that you hold. Then, as I mentioned, they can also ask to delete the information or get a copy of it so they can take it elsewhere. Again, all of these are new rights that most businesses do not have operationalized internally about how to respond to these requests. And if you get one request or two requests a month, that's not that hard to manually process. But think about how you would deal with this if you got 1,000 requests in one day or even one morning. That can be very challenging. So what happens if you do things wrong? Well, fortunately, there is only a private right of action, meaning an individual person can only sue you under the law if you've experienced a security breach. That is a big sigh of relief for businesses. For all other violations of the law, enforcement will come from the California Attorney General's office. Now, they do have the right to impose what are called statutory damages, meaning they don't have to show that somebody was actually harmed. If they can show that you violated the law and say you violated it with respect to 1,000 different California residents, then they can bring an action against you and collect $2.5 million. So damages can be very significant when a regulator has this right. They don't necessarily have to prove that these dollar amounts were incurred by the victims. And the California Attorney General's office is hiring more people as we speak right now to do enforcement of this law next year. There have been a number of amendments that have come out about the law. Probably one of the most valuable ones is that the definition of a consumer does not include an employee acting within the scope of his or her employment. When the law was originally passed and all these access rights and deletion rights were given, companies were asking, so if my employee calls me up and says, what information do you have about me? Where did you get it? Who do you share it with? We would have to tell the employee all about this? So the legislature passed an amendment to say, no, this is not intended to allow employees within a company to call up HR and get access to all their data or delete their data. If you de-identify data so that it is no longer reasonably linkable to an individual, then you're outside of the law. So there was an amendment passed to clarify that if you truly de-identify information and then aggregate it, it can't identify any particular individual. Now, a lot of people throw around aggregate or especially anonymous all over the place without thinking about what that really means. You may think a tracking cookie is anonymous. It is still personal information. If you want it to truly be de-identified, you need to break the link between the data and the individual or their device. Another amendment that was passed, the law requires that in order for an individual to exercise these access rights, there needed to be two methods to contact the business, an online method and a toll-free number. So businesses that were solely online businesses went to California and said, this is nuts, I don't have a call center. Why do I have to set up a toll-free number? And so they passed an amendment that said, if you operate exclusively online, you don't need the toll-free number. So let me talk about the timeline a little bit about what's happening. This law is coming down the pipe really quickly. It takes effect January 1st, 2020. So a mere 5 weeks from now. The law was passed last year. And the California Attorney General issued draft regulations to explain how the law is to be interpreted and applied. Now, you see I put the word draft in quotes. These regulations are not final, which makes this really challenging for businesses. There's a law, a very significant privacy law that comes into effect in 5 weeks, and we don't know what the final implementing regulations are from the California Attorney General. Now, you may say to yourself, Well, how can I comply with a law when I don't know what the standard is? Well, there was one amendment passed which prevents the Attorney General from enforcing the law until July. So the AG can't enforce the law until July 2020. But the Attorney General has specifically said, I don't care. The law is still effective January 1st. So come July, we can look back to January and see what you did wrong. So that is a really uncomfortable position to be in, that we have to put in place compliance procedures for a law that takes effect in 5 weeks and the regulations are not yet final. If you're scratching your head thinking, how are we going to do this? You're not alone. Lots and lots of companies are having implementation problems and doing the best they can at this point, because quite honestly, you can't be 100% compliant if the regulations are not final, but you can hopefully do a good job of getting there. So a few of the things I put on the screen here, we talked about the content of privacy policies, about 800 numbers. If you license personal data from a company upstream, you may have to get a signed attestation for them. And if you are the service provider who is processing someone else's personal information, they may as well ask you to sign something. The regulations introduced many new requirements, which makes this very challenging. One I put there is these opt-outs. If an individual contacts you and says, I want to opt out of the sale of my personal information, you're required now to go tell everyone to whom you sold the data within the past 90 days. The draft regulations also require companies to implement reasonable security measures so that if you have a security breach, they could allege you've done something wrong. When it comes to the retargeting and online interactive advertising world, CCPA has been a real challenge. As I mentioned before, when you have a retargeting pixel on your website and that pixel fires and drops a retargeting cookie on an individual's device, most interpret that as the sale of personal information. The website has enabled this third party to drop the cookie and collect data for its own purposes. So you need to offer consumers the ability to opt out of that sale of personal information. And you might think, well, how in the world do I do this? I know in the EU, they have those crazy cookie banners. Do I have to put these cookie banners in place if I have any cookies on my website? That's not the case, but you do need to have an ability for the consumer to opt out of the sale. You can simply put a do not sell my personal information link on the website. Then it raises the question, what happens when the individual clicks that link? In the retargeting and advertising industry, there is a trade group called the Interactive Advertising Bureau. They are putting in place a process to automatically process opt-outs in the online advertising ecosystem. Many in the industry have been racing to try and implement this by January 1st, but then yesterday, another trade association, the Digital Advertising Alliance, put out their own solution about how to deal with retargeted ads online. Again, very complex, and sitting here November 26th, when most companies have a moratorium on development work on their websites in December or after Thanksgiving, compliance is a real challenge. Most of my clients are figuring out what they can do now and what they can do after the first of the year. Okay, little known fact. There are other states in the United States besides California, and they too want to get in on the act. So it's not just California that is doing this. The trend with a lot of privacy laws around the US is to move away from the old regime of notice and choice. Just tell people what you're going to do, and they've got a choice whether or not to use your service. The new trend is transparency and data access. Much more detail about what you do, and allowing consumers the ability to control how their data is used. There are a number of states that have pending laws or laws that did not make it through their legislature. New York has one, the second one there, the Privacy Act, that may come back soon in New York, And this one could be even scarier than California because the current draft of the bill allows for a private right of action. So under that bill, if somebody contacted you to get a copy of their information and you didn't respond properly or in time, they could bring a lawsuit. And you know it would be a class action lawsuit. So we'll see what happens in New York, but that could be a very, very significant development even beyond CCPA. New York has enacted what's called the SHIELD Act. This codifies the obligation for businesses to have reasonable security procedures in place to protect personal and private information. And it defines what should be in that written program. So your organization must have a written information security policy that specifically talks about how your organization will maintain this information. If you don't have that written privacy policy, not only is it a bad practice, but you could be violating the law. Here's another reason to have that written policy in place. Ohio actually enacted a really unique law. They said that if you have a security breach, but you had a written and reasonable information security policy, you may not be liable for that security breach. There may be a safe harbor. They recognized that security breaches happen. They can't always be stopped. And if a company does their best to try and prevent a breach by having reasonable policies which address key issues that any smart company would address, you may not be liable then when those class action lawyers come knocking on your door. Okay, we talked a lot about California, but there actually is another opt-out law which is already in effect. Nevada implemented a privacy law. This law, and I have a few quotes here from the state senator who introduced it, was a key sponsor. And the middle quote there I think is very important. She said, as we can see, there is a trend in states taking on the issue of data privacy. Until this issue is addressed at the federal level, it's incumbent upon our state to ensure our residents are protected. So this law is already in effect. It is an opt-out law. It is just an opt-out law about that one particular issue, about the sale of personal information from people in Nevada. So if someone in Nevada reaches out to you today and asks to opt out of the sale of their personal information, you would need to, by law, if you are subject to this law, process that request. Now, you may not have as many connections to Nevada as you do California, and also the definitions are a little more favorable in Nevada. The definition of what's called personal information or covered information is a little narrower. It doesn't cover everything under the sun. And the definition of sale under Nevada was also a bit narrower. It's really selling personal information for money. So that's a little easier to deal with because it's not any transfer of the personal information. Under Nevada, they require you to process that request in 60 days, and you have to have an email address or a toll-free number or website, not both, where someone can contact you. What I think is very unique about the law, it allows the individual to opt out of the sale of the information you've collected about them or will collect about them. So I think what that means, and Nevada is not giving us any guidance, is that if somebody contacts you today and says, I'm in Nevada, I want to opt out of the sale of my personal information by you. You look through your records and you say, we don't have your personal information. You may need to keep a record of that because in case you get their personal information in the future, they have already opted out of sale. In terms of enforcement, again, no private right of action, thank goodness, but the Attorney General can bring fines of $5,000 for each violation. No enforcement yet on this one, but you can expect that it'll come at some point when there's a lot of money for the state regulators to pull in. So let's compare this for a second versus what's happened in Europe. And you may say that, well, Europe's got a more established regime, we know how to comply, but it's important to understand the differences. So again, still at the federal level, leaving aside California, Nevada, and others for the moment, privacy in the US is regulated by one sentence. In Europe, they have the General Data Protection Regulation, GDPR. GDPR is a huge law, 99 articles in the law and 173 recitals explaining what the law means. One of the challenges in the US has always been, how do we define personal information? I talked with you about how personal information is defined under CCPA and other state laws, but there is no one definition in the US. So if someone says to you, we don't collect any PII, that doesn't really answer much for you, because you need to know, well, what law are you looking at? There's HIPAA, the Health Insurance Portability and Accountability Act, which has a definition of protected health information. GLB, the Gramm-Leach-Bliley Act, has its own definition of non-public personal information. Each state has their own definition. So again, there's no consistency here. So if someone says to you, don't worry, we don't store any PII, that doesn't answer the question for you. That's to be contrasted with in Europe, where they do have a definition of personal data. It is extremely broad. It means any information relating to an identified or identifiable natural person, and it applies to pretty much everything. So let's do a little GDPR refresher, and then I'll do a little compare and contrast with CCPA, because the important takeaway is that if you've already put in place compliance programs from GDPR, don't be under the false assumption that you're automatically in compliance with CCPA, because you may not be. So I talked about what GDPR is, how lengthy it is. It began about 1.5 years ago. And why is it important? Well, we talked about fines under the California law and Nevada law. The fines under GDPR are astronomical. They can fine a company up to 4% of your annual revenue, or 20 million euro. That's a lot of money. And the fines on the GDPR front have been increasing. In the GDPR world, they talk about personal data being pretty much everything. They talk about anonymized data. If you break the link between the data and the individual or their device, you're then out of the law. But they also talk about pseudonymization and pseudonymized data. If you can't identify the individual anymore, but you can still trace it back to them, it is still covered within the law. You may have heard the terms controllers and processors. Those define the two key parties under GDPR. And you don't have to have an office in the EU for the law to apply to you. GDPR can apply to you if you're processing the data of EU residents or you're targeting your goods and services to residents of the Union. And California is fortunately not an opt-in law. It is an opt-out law. But in GDPR, it's sort of opt-in to an extent. You need to have a lawful basis to process any personal information. That's why you see cookie banners on websites, because in the EU, before you collect the personal information, you need to establish your basis in order to process that information. California, thank goodness, you don't have to do that. You just have to be very transparent about what you do. We talked about the breadth of personal data. It can include online identifiers and location data. And we talked about pseudonymization and anonymous data. If you could truly de-identify the information, you could get out of GDPR because it's no longer personal data. And GDPR only applies to personal data, as CCPA only applies to personal information. Under GDPR, just like California, individuals have access rights to access their data, to erase the data, to port their data over to another service. And many of you have probably signed DPAs, data processing agreements, because a controller and a processor under GDPR are required to have a written agreement that explains how the data is going to be used and processed. There are additional requirements under GDPR that don't exist in CCPA. A lot about internal information security. Those types of things are not in the California law. The California law is really focused on consumer-facing businesses, on the consumer's right to access their data. Again, I say the word consumer, but that means any California resident, even if they're using their business email address. GDPR has a breach notification requirement. That doesn't exist under CCPA, but that exists under other laws. GDPR has a record-keeping requirement. That doesn't exist under CCPA. You may have heard about the Privacy Shield framework. Another thing that does not exist under CCPA is cross-border data transfers. The EU requires that if personal data is transferred from the EU to a jurisdiction that's deemed to have inadequate security practices, that there needs to be a particular basis for that transfer. Believe it or not, the United States is deemed by the EU to have inadequate security practices. So a treaty was put in place to enable the flow of information properly, and that is the US-EU Privacy Shield framework, which is administered by the Department of Commerce. And you can apply to that program, and once you're on the Privacy Shield list as a US company, your company is now deemed adequate to receive personal data from the EU. We have just a few slides left, so if you do have questions, I encourage you to type the questions into the chat box, and Christina will read them to me, and I'll be able to answer a couple of your questions in just a moment. So as we were talking, I talked about the comparison between the two laws. Here's a little chart. So again, CCPA is an opt-out law, whereas GDPR, you need to establish that legal basis in order to process the personal information. Under CCPA, if you're dealing with personal information, you're either a business, a third party, or a service provider. Under GDPR, you're either a data controller, meaning you determine how the data is used, you basically own it, or you're a data processor. You are just performing services for the controller. Under CCPA, there's a definition of personal information. Doesn't really define sensitive data, but in the EU, they define sensitive data differently, and there are heightened obligations for information such as race, religion, and other sensitive information. Both laws have access rights, so people can access their data, but under CCPA, you need to tell people slightly different things about how they can exercise those rights. Internal data security is not a big part of CCPA. It is a big part of GDPR. GDPR may require your company to have a data protection officer, an individual charged with certain obligations. And then there are restrictions on cross-border data transfers. And the big thing is the fines. The penalties under CCPA can be $7,500 per violation at the maximum. Under GDPR, they can go to 4% of your annual revenue. So I talked about the challenges we have with California and Nevada and possibly New York and others. So what is the federal government doing to help us out here? Well, this is my only slide on federal legislation. There are a number of laws that are pending, but those laws have not been enacted. I think as more states pass laws like CCPA, and there's more of a conflict between the states, there's going to be more of an outcry from businesses that we need the federal government to step in and establish a consistent standard. That's what happened with canned spam, with email marketing. States were passing their own laws in the early 2000s, and it was becoming untenable for businesses to comply with all these different standards. So the federal government stepped in and enacted the canned spam law. So what should you be doing now? At a minimum, you should be reviewing and possibly updating the privacy policies on your websites and services. I say this for a number of reasons, but the most important is it's a very visible step. If you turn your policy into a CCPA compliant policy, then when a consumer looks at it, or a regulator looks at it, or maybe a class action lawyer looks at it, it looks like you're in compliance, regardless of what's going on in the background. Now, hopefully you are getting in compliance in the background as well, but the privacy policy is sort of your statement to the world that I understand this issue, I understand it's important, and I've taken steps to comply. Second thing you should be doing now is understand your data. It's hard to put in place compliance procedures if you don't know what data you have. Where does it come from? Where is it stored internally? How do you use it? Are you a business? Are you a third party? Are you a service provider? These are important things to determine, and then you can determine, do you have significant compliance obligations, or do you have pretty simple compliance obligations? Access requests. You need to think about, how would you respond to an access request if it came in from a consumer? If one came in tomorrow, I'm sure you could figure out how to respond to that one consumer. If 1,000 came in tomorrow, think about how you would process those. The law requires you to respond and process those requests within 45 days. And then contracts. You need to review contracts with your customers and your service providers and other third parties with whom you work to see if the rights are clearly set out and if any CCPA obligations are baked into those contracts. If not, you should update your forms going forward, and you may need to amend existing contracts. With that, we have 5 minutes left in the allotted time, so I'll stop there, and I'm happy to answer any questions that people may have on the topics I just discussed, or frankly, anything else related to privacy.